Good afternoon. My name is Becky Young. I am a partner and I manage the employment-based immigration practice at Grossman Young and Hammond, an immigration law firm in the Washington, D.C. area. I want to, first of all, acknowledge our co-sponsors for today's webinar, the Renewed Democracy Initiative and Abrahamic House. Thanks so much to those wonderful organizations for sponsoring this webinar with us, and hopefully some of the attendees are amongst their constituency. They both do really great and important work. I'd also like to introduce my colleagues, Sandra Grossman, my co-founder, who runs the firm's International Protection and Human Rights practice. Patrick Torrell, my partner who oversees our immigration litigation practice, and the newest member of the GYH family, Dree Colopy, who as of today is officially of counsel to our firm. Dree is a nationally renowned asylum expert. She wrote the book on asylum, and she is an adjunct professor at Catholic University. So we're very, very pleased to have Dree with us on today's webinar, especially considering the topics that we're going to be covering. So we are right now starting week 6 of Trump 2.0, and a lot has happened in the past 5 weeks. We have seen what many are describing as a flood the zone strategy, just really sort of a flurry of executive orders and policies like nothing that we've seen before. The emergence of the unitary executive theory, which is basically the idea that the president has unlimited power to control the actions of the executive branch. Dismantling much of the federal government, most notably, I think, in connection to the work that we do, USAID, and the termination, essentially, of nearly all foreign aid of the United States. Continuing ongoing reductions and uncertainty regarding the federal workforce. We'll talk a little bit more about that, but that impacts all of us here in the DMV and very much our work in the immigration field. Also some unorthodox ideas about Gaza and Ukraine. Elimination of a lot of research funding. And all of these topics are related to our work as immigration lawyers, so we'll get to that. But I'm raising them as background, but they're all connected to what we do. The last is a deal between Mayor Eric Adams in New York and the DOJ involving immigration enforcement in New York City. So that's all just background, but there have been many other actions that directly impact immigrants, and that's what we are here to talk about today. These actions impact both immigrants at the border and those within the interior of our country. We have seen arrests and removals of immigrants. We've seen the government sending immigration detainees to Guantanamo and other foreign locations. We've seen some actions with regard to TPS, termination of some parts of TPS for some countries. We've seen a lot of fear in immigrant community relating to the actions that are going on, kids not showing up to school because of reports of potential ICE raids. And we've seen a whole lot of cases filed in the federal courts, including the birthright citizenship case, which is headed to the Supreme Court. There have been some developments in the employment-based immigration space, which is where I practice. But to be very honest, they're really vastly overshadowed by some of the constitutional issues and other issues relating to humanitarian immigration, which is where my colleagues here practice. So we'll touch briefly at the end on the employment-based practice, but this webinar will be largely focused on humanitarian and constitutional issues related to immigration law. So I'd like to start with my partner, Patrick Torrell, who's going to talk about the extension of expedited removal as well as a potential travel ban.
Thanks, Becky. Hello, everyone. So the first topic I was going to cover is not really a surprise, neither is the second. It's just that there's likely to be a new travel ban coming, probably within about 25 days. So when I say travel ban, what I mean is what was called in the first Trump administration the Muslim ban. So how do we know this is coming? So there was a day one executive order that was called Protecting the United States from Foreign Terrorist and Other National Security and Public Safety Threats. And that executive order calls for several cabinet officials to provide the president with a list of countries throughout the world for which, and I'm quoting here, vetting and screening information is so deficient as to warrant a partial or full suspension on the admission of nationals from those countries. So that list is to be provided to the president within 60 days so January 20th, and that's where I get the sort of 25-day prediction for now. It was precisely an interagency working group like that one that produced the Muslim ban in the first Trump administration that the Supreme Court ultimately condoned in the Trump versus Hawaii case. So as a reminder how that travel ban worked, certain visa categories, and in some cases, all visas for people from those designated countries were basically suspended. They weren't allowed to be issued visas. This included a wide range of student visas and H-1Bs and immigrant visas in some cases. Countries that were impacted last time included Iran, Libya, Somalia, Venezuela, North Korea, Syria, and Yemen. And I would surmise that that list will grow with probably Afghanistan being added to it, maybe Haiti. Time will tell. People were exempt from that travel ban if they were permanent residents, but citizens of those countries. And I would expect for legal reasons that they're going to maintain that position. But as far as the particulars, we'll sort of have to see how it all shakes out. The second topic I was going to discuss is also not a surprise. It's the expansion of expedited removal. So what is this? Well, basically Congress has given the Department of Homeland Security the authority to remove certain people without judicial process where those individuals can't prove physical presence in excess of 2 years in the United States. Now, previously under, it was the bipartisan approach that this was going to be limited to people apprehended within 100 miles of the border and 2 weeks of entry, and that was largely for racial profiling reasons. But the Trump administration basically is expanding that to the maximum extent allowable by statute. And arguably, they're going beyond the statute in their interpretation, and that's something that's actually being litigated now in the DC District Court. So who's going to be subject to this expanded expedited removal? Basically, people who meet kind of two criteria. One has to do with like manner of entry or documents at entry, and the other has to do with physical presence. So, and you have to meet both requirements. So you either have to have entered without inspection or with fake documents or no documents, and you can't prove to the satisfaction of an ICE officer that you've been here for over 2 years. In this scenario, the ICE officer is really judge, jury, and executioner. There's supposed to be an escape hatch within the expedited removal process for people who express a fear of persecution in their home country. I have significant concerns regarding how this is going to be implemented. I'm sure many people do. Concerns about giving people a meaningful opportunity to prove their presence. The regulations don't say anything about access to counsel. They don't say anything about a duration of time that people should have to gather the documents they might have to prove their presence. They don't say anything about people with special needs. I mean, there's a whole range of process-related concerns. Will ICE disregard evidence proving presence, right? Here, there's no judicial oversight. And will ICE disregard claims that the person has a fear that they're going to be persecuted? And the reason I raise that in particular is that there's been some reporting in the New York Times recently about 3 plane loads of immigrants from countries like Afghanistan, Iran, and China that were flown to Panama. And these were people who were essentially locked in a hotel room, not given access to journalists, and they were communicating with those journalists through the windows of their hotels, and in some cases through phone calls with reporters that got their phone numbers. saying they were going to be killed, or pantomiming in some cases that they would be killed if they were sent to their home countries. And, if anybody on the line has ever worked with people from Afghanistan, you would know that there almost certainly was an asylum claim that was advanced. And yet, the New York Times reported that the secretary or the spokesperson for the Department of Homeland Security denied that any of those people had made asylum claims. So anyway, I'm going to hand it over to Dree, who's going to talk a little bit more about how expedited removal is going to impact, one particular population that's been in the news a lot, which is parolees, and then she's going to cover a couple of other issues as well. So Dree, I'll hand it over to you.
Thanks, Patrick, and hello, everyone. Thank you for joining us today. I'm going to cover some of the cuts that the Trump administration has made to humanitarian protections, and starting, as Patrick indicated, with the humanitarian parolees who have come in under some of the special parole programs initiated by the Biden administration. Under the Biden administration, there were several parole programs that were initiated to respond to recent refugee emergencies, such as the Taliban takeover in Afghanistan, the Russian invasion of Ukraine, and then the unfettered violence and political repression that's happening in countries like Cuba and Haiti, Nicaragua, and Venezuela. These programs are really effective in reducing the number of irregular border crossers and allowing safe and legal entry to people who were vetted and sponsored. But now the Trump administration has indicated in an executive order and in implementing memos that they intend to terminate these programs, which they refer to as categorical parole programs, that were initiated by the Biden administration. They have already announced the termination of the parole program for Cuba, Haiti, Nicaragua, and Venezuela, which affects over 530,000 people. No new applications are allowed under these programs, and no pending applications are being processed. And there were millions of pending Cuban, Haitian, Nicaraguan, and Venezuelan parole applications. DHS has indicated that it will also indicated, to Patrick's point about expedited removal, they have issued a memo indicating that they intend to review people who entered through these parole programs to see if they could be subjected to expedited removal. This is particularly concerning because most people, or many people who came in through humanitarian parole under these programs have been here for less than 2 years. And so they're particularly vulnerable if the administration does decide to apply expedited removal to that population. The administration also, in a memo, directed agencies to pause, modify, or terminate, effective immediately, any parole program that it believes isn't consistent with its view on parole. So that indicates that potentially, all the other Biden categorical parole programs are vulnerable as well. Let's see. In addition to that, there has been recent reporting, and I don't think anyone has seen the actual memo yet, but it's being reported that USCIS was ordered to, agency-wise, to stop processing any other benefit applications or requests by people who entered under 3 of Biden's parole programs, including Uniting for Ukraine, Cuba, Haiti, Nicaragua, Venezuelan parole, and family reunification parole. So what does this mean? It means that basically anyone who entered in those parole programs and who has applied for something else like asylum or TPS, that their applications are not going to be processed at this time. And practically speaking, it means potentially indefinite delay for people who entered under these programs and are seeking other more durable statuses, but it also means that they are prevented from obtaining another lawful status through USCIS. As a result, when their parole period expires or when the government terminates their parole status, which is possible, that they will have limited ability to protect themselves from removal. It also, I think, means potential delays for people of those nationalities, even if they didn't enter under those parole programs, because the agency will be vetting manner of entry or looking closely at manner of entry for everyone in those nationalities, even if it's not relevant to their benefit eligibility.
Dree, can I ask you a question? Someone is asking whether we think that the changes to parole programs could impact DACA. And I'm not sure we specifically plan to cover DACA during this webinar, but do you have an opinion about that?
I don't really see the humanitarian parole programs as being specifically related to DACA. But you know, I think any kind of programs like that are they're run by the executive agency and initiated by the executive branch, I think are potentially vulnerable, including, as DACA has been over the last, you know, multiple administrations, as the litigation, I believe, is still ongoing on that. So we're still, you know, trying to wait and see what will happen with DACA, but I don't think it's directly related to humanitarian parole, because that's a separate benefit that people have applied for.
Thanks for addressing that.
Yeah. So next I'm going to talk about TPS, temporary protected status. There's also been some changes to TPS under the Trump administration. First, the Trump administration revoked the Biden administration's redesignation of Venezuela for temporary protected status. Biden had decided to extend TPS for Venezuelans through October of 2026. But the Trump decision revoked TPS for a portion of the Venezuelan population that has TPS, meaning that about at least 350,000 Venezuelans on TPS will lose their TPS status as of April of this year. And then just last week, the Trump administration also decided to end TPS for Haitians 6 months early. It was supposed to be valid through February 2026, but instead the Trump administration has said that it's going to end August 2025. There's an estimated 520,000 Haitians on TPS that could then be vulnerable to deportation starting in August. Obviously, both of these countries, Venezuela and Haiti, remain unsafe for people to return to. And, you know, we don't know what is going to happen with the other countries that have TPS, but I think based on what has been indicated in executive orders and policy memoranda, that, you know, many of the other nationalities that have TPS are vulnerable to revocation as well. The Trump administration did attempt to revoke TPS for several nationalities back in 2017, and that was ultimately blocked by the courts. With the Venezuelan TPS this time and Haiti as well, there's been, at least for Venezuela, there's been 2 lawsuits filed challenging the revocation of Venezuelan TPS, brought by the National TPS Alliance and individual Venezuelan TPS recipients. Those arguments basically, or those lawsuits are arguing that the Department of Homeland Security has no legal authority to undo a TPS extension once it has already been made. They're also arguing that the administration's actions are motivated by racism in violation of the Fifth Amendment, right to due process. Lawsuits are expected to challenge the revocation of the Haitian TPS as well. So it's yet to be seen what will happen for those programs. For now, I think people are advising Venezuelans and Haitians who are eligible to continue filing for TPS, because if there is some sort of benefit from the class action litigation, they would want to have their application pending at that time in order to benefit from that. In addition to TPS, there's been several policy changes impacting asylum in the United States. And essentially the right to seek asylum does basically no longer exists at the southern border of the United States. With the Trump administration in its executive order declared an invasion of millions of illegal aliens, and I'm quoting that because I don't want people to think that I would use that language, at the southern border, and they have used those allegations to effectively seal the US-Mexico border to asylum seekers through multiple border measures. The administration ended the use of CBP-1, which was an application used to schedule appointments with border officials for the purpose of making a protection claim at the southern border. While there were many problems with the CBP-1 app, it was the only way for people to seek asylum at the border, even under the last administration. And so now that those appointments have been canceled and there's no way to make appointments, there's no practical way for anyone to seek asylum at the southern border. The Trump administration in its executive orders also invoked a statute in the Immigration and Nationality Act 212F, which gives authority to the president to restrict border crossings. They've used that to issue, quote, a finding that the invasion at the southern border, that there's an invasion at the southern border and that they will restrict border crossings until that invasion has ceased. The executive order cites public health, safety, and national security for the reasons, and explicitly excludes people's right to seek asylum. This suspension of asylum processing at the border has been challenged in federal court, and the litigation is ongoing. And I expect that there will be several other lawsuits as well. Another executive order deployed U.S. armed forces to the border to seal the borders and repel forms of invasion, including unlawful mass migration. This executive order is particularly concerning because it seems to encourage use of force against migrants at the southern border, and deploying the military to the southern border is brings up a lot of concerns. Another border policy that has come back is Remain in Mexico, or the Migrant Protection Protocols is what they were officially called. This program is a policy that requires migrants to stay in Mexico for the duration of their U.S. immigration court proceedings. It was initiated under the first Trump administration and then was terminated in 2021. Under the first iteration of it, nearly 70,000 people were deprived of a fair opportunity to seek relief. Only about 10% had legal representation in their hearings, and only 1.1% were ultimately granted relief. All while being preyed upon by organized criminal groups and cartels in Mexico while awaiting their hearings. The program was the subject of extensive litigation when it was around until 2021, and now the restart of the program is being challenged as well by the Immigrant Defenders Law Center. They have filed a motion requesting an emergency stay of the re-implementation of the program, but that remains pending as well. The Trump administration is also expected to issue a public health order labeling migrants at the southern border as risks for spreading diseases and resulting in their expulsion. Under the last Trump administration and being left in place during the Biden administration, they invoked Title 42, which is a health law basically saying that people can be expelled at the border if there's a public health risk. That was used in 2020 during COVID, during the pandemic, and was then left in place by the Biden administration. It sealed off the border to asylum seekers. It fueled basically repeat crossings, because if people were expelled, they would just try again to seek protection. It was challenged in the courts by the ACLU and others, and ultimately Title 42, the prior use, expelled nearly 3 million people before it was allowed to expire in May of 2023. There are reports that the Trump administration is going to bring this back, referencing potentially measles and tuberculosis. In 2023, Stephen Miller told the New York Times that this would happen, and citing, and I'm quoting him now, severe strains of the flu, tuberculosis, scabies, other respiratory illnesses like RSV, and so on, or just a general issue of mass migration being a public health threat and conveying a variety of communicable diseases. And so this is expected soon. And we don't know exactly what it will look like, but it's another border measure that will basically continue to keep the border closed to asylum seekers and others. That's all on the border. And next I will move on to, so it wasn't just asylum seekers who are being targeted, but also the refugees as well. So the Trump administration has effectively dismantled the U.S. Refugee Admissions Program. They've halted in an executive order indefinitely the U.S. Refugee Admissions Program, meaning no refugees are being admitted to the United States. This affected all stages of processing, from initial applications through travel for approved refugees. Some had already been approved, had their documents to come travel to the United States, and some were even, there were reports that some refugees were even forced to get off the planes before they took off for the United States. The suspension of the refugee resettlement program is subject to review every 90 days, but organizations expect it to be indefinite without the help of litigation. The International Refugee Assistance Project filed a lawsuit challenging the suspension of the program in early February, and that remains pending at this time. The Trump administration later issued an executive order to make one exception for refugee resettlement for white Afrikaners from South Africa. Those are the only refugees who can resettle in the United States at this time. I think that is enough depressing humanitarian news for the moment.
And Dree, maybe if I might, there are a few questions that relate to the topics you've been covering. There have been a few questions about Ukrainians. Obviously, that's been in the news quite a lot. Someone asked if you could briefly discuss how Ukrainians on humanitarian parole or who have asylum claims pending may be affected. So if you have any particular thoughts about Ukrainians, would you share those?
Sure. So I think, like anyone who's come in through the humanitarian parole programs that are nationality specific that were initiated under Biden, at least right now, Uniting for Ukraine still exists, but they're not accepting new, or they're not processing new applications from what I have heard. They haven't terminated humanitarian parole for Ukrainians at this time, or but it remains unknown whether they will just terminate humanitarian parole or whether they will just allow it to expire and not renew it. The Biden administration did allow re-parole for Ukrainians, meaning if their parole was expiring, they could apply to basically renew it. And so, that still exists on USCIS's website. I don't know, though, that they're really approving any re-paroles at this time. What does this mean for Ukrainians that entered on Uniting for Ukraine? I think, like any humanitarian parolee, I think it's really important for those populations to try to have really good, thorough legal consultation with an attorney so that they can kind of identify any potential options that might be available to them beyond humanitarian parole. And I think that they should, do know your rights, read all the know your rights information that's out there. And there's a lot of good resources out there. People who are not US citizens still have rights in this country, and it's important for them to know that. And yeah, I don't, with the reporting that additional benefits applications for these parolees are not being adjudicated as well, I don't know what will come of that, but I think people should still apply for any other benefit that they're eligible for, because even just having a pending application can be some sort of security for them being here. But I think the humanitarian parolee populations are in a very vulnerable situation, unfortunately.
And there was actually a question about Afghan parole. Do you think that those who entered under the Afghan parole will be affected? I think you can answer that question. You kind of just did, but if you want to say anything specifically about Afghan parole.
Sure. I think, it's kind of the same for all of these programs. The only program that has been kind of singled out and specifically mentioned is the Cubans, Haitians, Nicaraguans, and Venezuelans program. But the executive orders and the memos have indicated that all of these categorical humanitarian parole programs, they view them the same, the administration. And so, and they've hinted that, all of these programs are going to be reviewed to determine if parole remains appropriate. And humanitarian parole is a discretionary benefit. And it, even not under Trump, even just as humanitarian parole existed previously, it can be terminated at any time for no reason. Like the law allows that and the regulations allow that. So, what the Trump administration has done is say, we're specifically reviewing whether these categorical programs remain appropriate. So I think, we need to just be aware of that. And I think that these populations should be applying for any other potential benefit at this time.
Yeah, I think that's an important theme is, explore, if you do have one of these temporary statuses, please explore all possible alternatives. Before we move on, one other sort of similar question. Do you believe that TPS for Salvadorans could be impacted?
I think it could be, yes. I mean, it was targeted under the last Trump administration, so I would imagine that it, would be vulnerable again. And, I don't know if they've learned lessons from the litigation that, they lost last time, and they'll kind of change their strategy. I don't know, but I do think, many of the TPS programs are probably pretty vulnerable to being at least allowed to expire. I think kind of the revocation of ones that had already been extended is legally very questionable, and we'll see what happens with those lawsuits. But as far as allowing them to expire and not, redesignating or extending the status, I think is a possible reality that could be soon.
Thank you.
I also, just to add to that, I think the closeness of the Trump administration with the Bukele government could also be an indication of at least not redesignating or extending TPS. There seems to be a closeness of the two administrations and a lot of cooperation on immigration issues. So maybe that's an indicator as well that it's likely to end.
Should we transition to Patrick?
Sure. So I'm going to talk about a couple of things, some predictable, some not. The first one is the sensitive locations policy that's been in the news to some extent. So on day one, there was a memo that was issued by the acting secretary of the Department of Homeland Security, who's now been replaced by Kristi Noem, that rescinded a memo by President Biden's Homeland Security Secretary, which had, basically disallowed immigration enforcement action in sensitive locations. So schools, medical facilities, places of worship, playgrounds, domestic violence shelters, demonstrations. Enforcement action was permitted in certain narrow circumstances, like if there was a hot pursuit or an imminent risk of death or violence, something like that. But anyway, that policy is gone now. Does this mean that, ICE can, go into the inner sanctum of a church? No, not necessarily. ICE is now going to be allowed to enter, they will not be prohibited under their own policy from going to any of those sensitive locations. But the Fourth Amendment, still applies. And so they won't be able to enter into private spaces in those otherwise public spaces, right? So if a hospital waiting room, for example, ICE could show up there, but they won't be able to, go beyond that if members of the general public aren't allowed to, absent, unless they were able to, get a warrant, not an ICE warrant, but a warrant signed by a judge. And we can talk more about that if folks have questions. Second topic I wanted to talk about was this Department of Justice memorandum on prioritization of immigration-related prosecution. So the Attorney General, Pam Bondi, on, I believe, the day that she was sworn in, issued a memo called General Policy Regarding Charging, Plea Negotiations, and Sentencing. And this kind of echoed a memo that was issued within a few days of the inauguration by the acting Attorney General, that basically this makes immigration enforcement, particularly, it makes the prosecution of criminal statutes that deal with immigration a priority. And it basically directs DOJ to use all available criminal statutes to combat what they say the flood of illegal immigration that took place over the last 4 years. So it specifically this is the part that was surprising to me. It specifically calls for prosecutions of very minor conduct, like failing to file, a change of address form when required to do so. This is important as well. There's one for failing to register for a fingerprinting or registration program that they apparently want to stand up, and then I'm going to talk about in one quick second. But before I do that, I just want to say, I guess we'll see how the rubber meets the road on this in terms of whether U.S. attorneys' offices are really going to allocate the resources to, prosecuting those crimes and, at the cost of ignoring, the much bigger fish that they traditionally have focused on. So let me talk about this fingerprinting and registration program, because this is surprising and this is a very big deal. So an executive order that Trump issued on day one requires the Secretary of Homeland Security to ensure that all previously unregistered non-citizens in the United States comply with certain requirements in the statute regarding registration. What am I talking about? So the Immigration and Nationality Act kind of contemplates that immigrants are supposed to be registered under some sort of process. No process was ever created to sort of do this for, undocumented immigrants. There's lots of kind of registration processes for permanent residents, right? Like you kind of get a green card and you get a document that identifies that you've kind of gone through an immigration process and are known to the government. But they apparently want to stand up a program to have basically all immigrants who have not been registered, who live in the country, show up for this registration. I'm guessing it's going to be fingerprinting. And the executive order requires the Attorney General and the Secretary of Homeland Security to ensure that failure to comply with those legal obligations is treated as a civil and criminal enforcement priority. So what does this mean in practice? I mean, I think that if for those of you that might remember, after 9/11, the INS and then the Secretary of the Department of Homeland Security kind of developed this program called NSEERS, which was required nationals of a bunch of countries, all of which were Muslim majority, to show up for fingerprinting and basically be registered. And this led to a lot of deportations. I think they're going to try to do something like that, but for, you know, millions of undocumented immigrants. Okay, so going back to that DOJ memo on prioritization, it calls for data regarding immigration investigations and, importantly, declinations to prosecute to be collected and reported. And this is one of those little bureaucratic ways that they're probably going to increase compliance with an order that might otherwise, you know, not get a lot of respect in the field. Third topic I want to talk about was just briefly, the deputization of other federal agencies. So there was a directive by the acting Secretary of Homeland Security that basically gives certain components of the Justice Department the authority to investigate and apprehend what they call illegal aliens, but the meaning of that is unclear. Does it mean undocumented people? Does it mean visa overstays? Does it mean any removable person, including permanent residents? All of the above. It does, you know, that's one of the problems with that term, among others. So which, you know, components of DOJ are now deputized to basically act like ICE officers? The U.S. Marshals, DEA, ATF, DEA is the Drug Enforcement Administration. ATF is the Bureau of Alcohol, Tobacco, and Firearms, and BOP, the Federal Bureau of Prisons. The next topic I wanted to cover is the Laken Riley Act. This is not something the administration did. This is something that Congress did. Earlier this year, Congress passed and Trump signed the Laken Riley Act. And this law makes a number of changes to existing law, including allowing states to sue over the use of parole or over decisions not to detain individuals who arrive at the border without valid documents. But perhaps the most important change is that it expands mandatory detention. So to understand what that means, let me just quickly explain kind of how detention works pending removal proceedings. So the general rule is that ICE has the authority to detain any person who's in removal proceedings. They often choose not to because resources, because somebody may be a breastfeeding mother, or who knows what the circumstances are. But ICE often chooses to just let people go, either on a bond or on their own recognizance or with an ankle monitor or whatever. But on many occasions, ICE does choose to detain the person. Of that population that stays detained, the default rule is that you can go and ask an immigration judge to release you on a bond. The exception to that rule is if you're subject to what's called mandatory detention. If you're subject to mandatory detention, the immigration judge generally cannot release you. There's some limited exceptions when it becomes prolonged and unconstitutional, but like in general, you're going to be in detention the entire time your removal proceedings are pending. The mandatory detention statute, the law covers, people who've committed certain crimes. Some are serious crimes, but some are not. But what they've done now is expanded it basically to, they've expanded it to include a whole lot of people that wouldn't have otherwise been included. So who is included now? People have to meet two requirements. There's like a kind of criminal component, and then there's an entry component. So the person needs to have entered the United States without inspection, without valid documents, with fraudulent documents. That's part one. And then part two is they're subject to it if they entered in that way and are charged with, arrested for, convicted of, admit having committed a series of crimes. And I just want to repeat that: charged with or arrested for, right? So this presumption of innocence is sort of gone here. And if you are simply accused of one of the following crimes that I'm going to list, then and you entered in the manner that I described, then you're going to be subject to detention the entire time your immigration case is pending. And an immigration judge cannot release you even if you're not a danger or flight risk, right? The judge isn't even supposed to consider that. The list of crimes: burglary, theft, larceny, shoplifting, assault on a law enforcement officer, or any crime that results in death or serious bodily injury to another person. The last topic before I hand it over to my esteemed colleague Sandra is Gitmo. So there's a lot. I don't have too much to say about this because I don't have any insight that hasn't been reported. It's obviously a black hole, and I think selected because it is a black hole, but there's been some great reporting by Carol Rosenberg at the New York Times and others that share the little that we do know. So apparently they want to use this as a staging facility for people already ordered deported who are awaiting removal. Just, I believe, within the past couple of days, a second group of deportees have been brought to Guantanamo. The first group consisted of 178 Venezuelans, and they were removed last week. But the new group includes men from other Latin American countries. Honduras was mentioned and several others. But this is a developing story, so stay tuned. I mean, the executive order on this called for building a sizable facility that was going to house many, many people. It doesn't do that yet, but we'll see how what Guantanamo ultimately becomes. Okay, Sandra, hand it over to you.
And actually, Patrick, before you do, if I could weave in just a few questions from the chat or the Q&A. So someone asked the question, I think you've largely covered this, but just in case there's any aspects that miss, this person said in general, who will be detained and is it more difficult to bail someone out now? So if you feel like there's any aspect of that question that you didn't just cover, if you could touch on that, please.
I think, the mandatory detention statute, the major expansion is the one that I described. So I don't think there's anybody else that's going to be sort of, I mean, they're going to use more detention, I guess, more liberally. They will, even for people who are subject to discretionary detention, right? Who can be released, who ICE has the permission to release under the law. But, that's still going to turn on capacity, and they're still building that up. So right now, they have, I don't know how many, 40,000 beds, but I was reading that they're trying to get military facilities to allow detention of immigrants in those locations. So as they ramp up detention capacity, we're going to see more and more people that ICE otherwise probably would have just released be detained.
Okay, thank you. And then a question actually from early on the first topic that you covered, which is a potential travel ban. Someone asked if you think there's a likelihood that Ukrainians would be included in a new travel ban. Do you have an opinion on that?
That would surprise me. I haven't heard anything of that sort. And, I think, I don't know, it would... If the stated rationale for this travel ban is that these countries do not provide adequate information, I'd be surprised if a country as developed as Ukraine is included on that list. Now, obviously, it's been in a state of war, and I don't know, how effective their sort of, information sharing is with the U.S. government regarding, Ukrainian nationals has been, but I'd be surprised if Ukraine is included.
Okay, thank you, Patrick. Sandra, over to you.
Thank you, Becky. Thank you, Patrick. I'm going to briefly touch upon enforcement and some of what Patrick was talking about, this kind of broader use of ICE detention. And then I'm going to talk about increased vetting at the U.S. consulates for visa applicants. And then I'm going to close out with going over the birthright citizenship issue that I'm sure we're all reading about in the news. And I think what Patrick was saying about, and I saw there were a couple questions too about detention. What we're seeing from our side in the practice is that there's obviously, there are quotas that ICE agents need to fill. They need to be responsible for detaining and deporting more people than before. And what I have seen specifically in our international protection practice is several cases of individuals that have criminal allegations unproven from other countries who have come to the United States lawfully with visas and then are seeking asylum, have pending asylum applications. And what we're seeing is examples of those people being arrested and detained by ICE. In the cases that I have worked on personally, there have been Interpol red notices involved. So these are specific cases where whatever country that individual was coming from was either being prosecuted or had been convicted of a crime in their home country, and then came to the United States, like I said, applied for asylum. Under the Biden administration in October of 2023, there was an ICE policy, a directive passed that instructed ICE agents to take a much more nuanced approach to red notices. In other words, before arresting someone with a red notice, they should look at the general circumstances where the red notice was coming from, if the individual had applied for asylum and had a credible claim. And again, what we're hearing is that that sort of ICE directive is not being properly implemented, and people are being detained and then denied bond by ICE. Although I will say, because the idea here is to give a balanced approach, that we also saw actions like that under the previous administration. So, but it's definitely not getting better. The next issue I wanted to talk about was increased vetting of visa applicants and consular matters. So just for a little bit of context, and maybe a lot of you who are participating on this call have yourself applied for a visa to come to the United States. Most people, unless they are eligible for visa waiver, have to do that. They have to submit either an immigrant or a non-immigrant visa application in a series of forms in order to show that they are not only eligible for the visa, but also admissible to the United States. And what's interesting is that this has always been, I would say, a relatively difficult process. There is numerous different layers of vetting that goes on, not only by the State Department, which is the agency that's responsible for receiving and adjudicating visa applications, but also by a series of different law enforcement agencies that make sure that whoever the visa applicant is doesn't pose a threat to the security of the United States, that they don't have certain communicable diseases, that they haven't committed certain kinds of crimes. So that has always existed, or has existed for a long time under our federal immigration laws, and it's already a challenging process. But what we're seeing now under the Trump administration is a series of executive orders that aim to increase this vetting for visa applicants. There's two of them that I'll cover. One of them was on February 12th, and it's an executive order called One Voice for America's Foreign Relations. And that executive order aims to, quote, maintain an exceptional workforce of patriots to implement the policies under the order, end quote. And the order states to consular officers and foreign officers that failure to faithfully implement the president's policy is grounds for professional discipline, including separation. So what does that executive order state, other than sort of threatening consular officers and foreign affairs officers? It's a series of different directives on how they're going to reform the functions of visa processing. One of the most important, and I was also surprised Patrick used that word previously, reforms, is that they're directing the Secretary of State to revise or replace the Foreign Affairs Manual and the Foreign Affairs Handbook. So the Foreign Affairs Manual is a collection of policies, procedures, and organizational structures for the U.S. Department of State, and it lays out in numerous different sections how consular officers should adjudicate visa applications. And it really governs visa applications. And we as immigration attorneys also look to the Foreign Affairs Manual to help our clients and us understand the criteria that consular officers will look at, and what the policies are that will be applied in visa application procedures. Apparently, that's all going to be revised or replaced. And by the way, here again, the FAM, the Foreign Affairs Manual, is constantly being revised, and there are new sections being added and taken away. So in and of itself, it's not that unusual, but the idea to replace it, I would say, is unusual. I'd also note that some of the directives in the Foreign Affairs Manual are promulgated by statute. For example, the Secretary of State's authority to prescribe regulations for the Foreign Service. These are provided for under the Foreign Service Act. So here I would say that there's a likelihood there of some judicial challenges because the president does not have the authority to overrule or supersede a statute. A second order that I think Patrick touched upon as well is it's called Protecting the United States from Foreign Terrorists and Other National Security or Public Safety Threats. So just reading over this executive order, it again instructs individuals that are adjudicating visas to be quote unquote vigilant during the visa issuance process to ensure that those aliens approved for admission into the United States do not harm Americans or our national interests. And then it goes on to say that aliens otherwise already present in the United States do not bear hostile attitudes towards its citizens, culture, government institutions, or founding principles, and do not advocate for, aid, or support designated foreign terrorists or other threats to our national security. So again, the language in this order is impactful in that it purports to implement this increased vetting and screening across a variety of agencies. But again, I will say that this language is already contained in our existing federal immigration laws. There's a host of grounds of inadmissibility, including for health, criminal, and security related grounds that would make a person inadmissible to the United States that are already there. Finally, and I think Patrick talked about this, is this order calls for this report to identify countries which are deficient in their vetting and screening mechanisms. So what do these two executive orders mean for visa applicants? I think we can expect, as we did under the first Trump administration, that visa interviews are going to be more challenging. And I think part of that is that, you know, consular officers are going to be more concerned about their own jobs and careers. And they may implement more restrictive interpretations of guidance. Two, I think if the Foreign Affairs Manual is revised or just wholesale discarded, there could be a lot of inconsistency in visa application decisions as consular officers, you know, interpret any new guidance from without that, without the benefit of the Foreign Affairs Manual. I think we're also, because of the combination of these two executive orders and the fact that lots of consular officers with experience may already be leaving the Foreign Service, I think we may get a core of people working for State Department that may be extremely attached to keeping people out of the United States. And then this could lead to what we saw during the first Trump administration, which was very long backlogs in visa processing, family separations, and also an impact on U.S. competitiveness because of employers that are waiting for foreign workers to come to the United States. Visa applicants should expect that officers will really review documentation more carefully and are going to look closely at individuals' social media history, their travel history. There was a form under Trump 1 that was required, especially for individuals from certain parts of the world. So people on this call, and if you know people applying for visas, it should be really careful about social media postings and being ready for those kinds of questions. So that's what I have to say about increased vetting at consulates. And now I'll just turn to the issue of birthright citizenship. I think I saw at least one question about that. So his first day in office, Trump issued an executive order to end birthright citizenship for certain children born in the United States. I'm going to explain who this order affects. Then I'll provide a very brief history and context on the issue of birthright citizenship. And then I'll end by explaining the status of legal challenges thus far and the potential impact of the executive order if it is allowed to stand. And I do think this is an issue with tremendous implications for the rights of non-citizens in the United States. I mean, the more that I read about this and prepared for this webinar, I think it's not an overstatement to say that this could be a very defining issue on constitutional rights for immigrants. So in terms of unpacking the order, who does it affect? So a child born in the United States would be denied citizenship at birth if their father is not a U.S. citizen or lawful permanent resident, and their mother is either undocumented or has a temporary status in the U.S., such as, for example, is here on a visitor or student visa or a temporary work visa. So you can imagine a child born, for example, to an undocumented mother whose father has a student visa. That child would be denied citizenship. Or another example is a child being born to a mother who entered on a temporary work visa and whose father is a derivative on that visa. In other words, they get the accompanying status. Those people are here lawfully, but that child would also not be a U.S. citizen under this order. It's also important to understand who is not affected. So the executive order does not revoke citizenship for anyone who already has it, okay? So you're not gonna get your citizenship revoked, at least not under this order. It applies only to children born within the US starting 30 days after January 20th, 2025, which was the day the order was issued. So children being born today, and a few days ago to the classes of parents that I just described would be impacted by this order. So to understand kind of what the arguments are on both sides with a view towards unpacking whether this order is likely to stand, I'll just relay some brief history about birthright citizenship in the United States. So I would go back to 1857 to the Dred Scott case. And in that case, it's a very notorious Supreme Court decisions where the Supreme Court denied birthright citizenship to the descendants of slaves. And the court stated in the Dred Scott decision that enslaved people could not expect any protection from the federal government or the courts. Soon after the Civil War, and to undo that decision, Americans abolished slavery in the 13th Amendment, and then they adopted the 14th Amendment to protect citizenship for children born in this country, in part a reaction to the Dred Scott decision. And this part is really important for all of us trying to understand this. What does the 14th Amendment state? Well, the Citizenship Clause says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. So the key part of that is subject to the jurisdiction of the United States. And that's really where I think we're going to see, and where we're seeing all of the litigation about what does that mean. Well, so for well over a century, this has been an issue of settled law, in that the Supreme Court looked at this, and there were statutes that were legislated that establish that people born in the US are, quote, subject to US jurisdiction. And what that has meant in previous Supreme Court cases is that people that are born here, even if they entered without documents, are bound to comply with the law, right? There's an expectation that because they're in the United States, they will comply with the law, and that the United States is also bound to offer them protections, like, for example, constitutional protections and due process. At least that's how this was interpreted in the past. So this is different, for example, and that in the case of a child that is born to parents who are diplomats, because the idea there is that those diplomats have an allegiance to another country. They may in fact be immune from certain sections of US law. And so those children of diplomats, certain types of diplomats, would not receive US citizenship. And again, this reasoning has been settled law for well over a century. So there have been numerous challenges to this executive order. The one that's sort of moving up the appeals process most quickly is a case that was filed in district court in Seattle. And that case is now being heard by the Ninth Circuit Court of Appeals. There was a temporary restraining order that was put in place by a U.S. District Court judge in Seattle, and the Ninth Circuit declined to remove that order. And so the Ninth Circuit should be hearing this case on the legality of the executive order. I read sometime in June, and then, you know, both sides are likely to appeal, and it could go to the Supreme Court after that. So in terms of the impact of the order, and I'll end with this, is we can expect numerous sort of immediate practical implications in that an untold number of babies born in the United States each year will no longer enjoy the benefits of citizenship. Those, and really in reading the impacts, what we're getting is a picture that it would create this sort of underclass potentially of people with not only without any status, but who would be forced to live under the threat of deportation, who would not be eligible for a really wide range of federal services and programs. They couldn't apply for a social security number or a passport, and really lose the ability to be part of American society, and then potentially also be stateless, depending on maybe their parents' country of origin. So there's questions around what citizenship, if any, these children would have. And I guess more broadly, and this is where I think the impact, like I said at the beginning, could be really varied, is that, you know, in reading these decisions, a Supreme Court decision that upholds this executive order would have to find that undocumented people are not subject to the jurisdiction of the United States. So that could mean, for example, that undocumented people are also not covered by other constitutional protections, like the Equal Protection Clause of the 14th Amendment, which states that no state can deny equal protection of the law to any person within its jurisdiction. That clause has been used to strike down laws that discriminate against undocumented people. For example, laws that bar undocumented people from attending public school. So again, if this executive order is allowed to stand, it could open up really a floodgate of new kinds of cases, which would deny all sorts of constitutional rights to persons born in the United States. So of course, we will be following this issue closely at GYH. Unless there are any, oh, go ahead.
Yeah, there are some questions. So first of all, I think there's a question, and this person says they got slightly confused by the wording of the birthright citizenship rule. And my understanding of the birthright citizenship executive order is that anyone who is here in the US on a non-immigrant visa would not be able to convey citizenship to their children. So it doesn't matter whether it's the mother or the father, like I'll read you this question, but I think that we should hopefully be able to sort this out. So it says, you mentioned if the mother has a lawful work visa and the father has an H-4, the child would not be able to be granted citizenship. So the bottom line is that if both parents are on a temporary visa, the child is not getting citizenship.
Correct. I agree.
Yeah. Okay.
With that conclusion. Yes. Yeah.
There also was, I think this is more of a comment than a question, but it relates to a red notice. So I just wanted to share it with you in case you have any thoughts, because I know that's your area of expertise. This person says, I have a red notice. I went to check in at ICE last week. I wasn't detained. No questions asked. Probably the policy is still new. Not sure what happened. So I don't know if you have seen that particular issue.
Yeah, I don't think that we can say that there is consistency across different jurisdictions as to how ICE would act in any particular case. There may be, some offices that look at red notices and, will decide to arrest and detain. Other officers may act differently. And that's part of the problem here, is that there's such broad discretion. So I think we're going to see a variety of reactions in different places.
Okay. Thank you. And then one other question. I'm not sure whether this was in response to something we said, but someone was commenting that the form DS 5535 was in continued use through the Biden administration as well, which has been my experience. So
yeah, I think ours as well. I see some nodding here. Yeah. And that actually goes to my point that I was making, is that it's, there've always been challenges to consular processing, and there's no right to a visa, right? It's a discretionary benefit. And so whenever a consular officer basically feels it's appropriate, they can subject a person to increased vetting, which is already happening.
thank you.
Mm-hmm. I think I was supposed to pass it back to Patrick.
I think Dree actually.
Sorry, I knew I was going to get that wrong. All right, Dree.
Yeah, and I just have one small topic to just touch on that goes along kind of with what Sandra was sharing about kind of increased vetting and long timelines and all of that. So obviously everyone's seen in the news the personnel changes in the government with the many federal employees being laid off or not continuing with their hiring process. So just mentioning this, that, DHS has fired 400 probationary employees. In addition to that, at least 20 immigration judges have been fired amid massive case backlogs. I think it's at the end of last year, it was 3.7 million cases in the immigration court backlog. And more recently, it's been reported that for the size of the Board of Immigration Appeals is being cut down to 14 members, so nearly in half. When appeals are already taking about 5 to 6 years, I think, on average, some even longer. Just sharing this kind of the personnel changes as to make everyone aware that I think timelines for processing of benefits applications, timelines for immigration court cases, timelines for appeals, I think are all going to continue to skyrocket. And, they're already at, I think, historically long processing times for many things. So just, as you're moving forward, just planning ahead for that, for, I think, longer processing times are in our future. Mm-hmm. And then I think Becky has a couple of final topics to share with us.
A couple of final topics to share. I do want to turn back to the birthright citizenship issue, and Sandra, maybe you can help me out here. So this definitely, when I read about this birthright citizenship policy, it concerned me for many reasons, aside from the constitutional implications. The practical implications for my clients, a lot of whom are in the US in a lawful work authorized status. And so if someone is in the US, let's say on an H-1B visa, and they have a child here, and that child does not have US citizenship, so normally if you bring a dependent with you to the US, that person has to get an H-4 visa, but there's no process to get an H-4 for someone. If they're born, they don't have status. You can't get status in order to change your status to H-4, you have to have a status. So if you're born in the US and you don't have any status, there's no procedure in place, because this has never happened in the past 100+ years. So I think, first of all, this is going to the Supreme Court, and, we're going to see what the Supreme Court says about it. I am holding out hope that the Supreme Court will, uphold the century-plus precedent that we have. But in the event that they don't, I don't know if any of the panelists have any thoughts about what somebody would actually do. There are stateless people. There are kids that would be born stateless, but even if the kid is not stateless, you can't take a newborn baby overseas to get it a visa. So I don't know, honestly, what the practical implications would be.
I'm interested. This is a really important issue, Becky, and thank you for introducing it the way that you did, and with just tremendous practical implications. I'm interested in what my co-panelists might say, but just a couple of things. The current executive order is subject to a temporary restraining order, which has not been removed by the Ninth Circuit. So it's my understanding that at this point, Patrick, I don't know if you have an opinion of this, because the TRO is still there, that children that are born here would continue to be US citizens at birth at this point.
Absolutely.
Right.
And there's even other
Okay.
injunctions as well that are like overlapping. Yeah.
Okay, good. So that's one point. The other point, just in preparing for this panel, I was reading some of the precedent cases, some of these old Supreme Court precedents establishing birthright citizenship. And I'm concerned, actually, I'm not as optimistic, or maybe, I don't know, Becky, if you were optimistic or not, but the sort of pivotal case was, I don't know, in the 1860s, but that case involved the child of two Chinese nationals who were lawful permanent residents in the United States. And the executive order specifically excludes lawful permanent residents. And so, I don't know how prepared they were for this executive order, but there's a distinction there that is concerning, and one that could be used to rationalize, ending birthright citizenship. It's also unusual. I think US is only one of 30 countries that has birthright citizenship.
Yes, absolutely.
Yeah.
I think, there's that pesky subject to the jurisdiction clause, like how can, if someone in H-1B status is not subject to our jurisdiction, then they could commit a crime without we wouldn't be able to arrest them if they weren't subject to our jurisdiction. Right. So that part seems a little problematic to me. But my hope is that in the event the Supreme Court does side with the Trump administration, that at least they would then create a procedure for someone who is an H-1B who has a child in the US to get H-4 status automatically, because that otherwise is going to create a big mess. And I'm, for the person who posted this comment, I'm sorry that you're going through this right now, because that's a pretty crazy, it's a pretty crazy situation, and not one that we would like you to be in.
Becky, could I just offer one practical suggestion for folks?
Yes,
that
please.
If you have a child, if your child is born after that executive order takes effect, I would apply for a passport as soon as possible, in the event that these injunctions get lifted. And I think it'll be difficult for them to unwind citizenship for those folks who have already been bestowed passports and other citizenship.
Yeah.
And just one other quick thing, that there's a procedure now called recordation of lawful permanent resident status for individuals that are born to foreign diplomats, certain kinds of foreign diplomats who otherwise are not eligible for U.S. citizenship. They are entitled, because they were born here, to receive lawful permanent resident status. So there's a procedure that exists, that has existed for a long time, and maybe that's what we'll be looking at.
Thank you. So there are a few sort of comments on the employment-based front that I did want to make, and then if we have a few minutes remaining, we do have a few additional questions. I've been doing my best throughout the presentation to address employment-based questions as they come up. And I think, from the perspective of an employment-based immigration lawyer, the good news is that the administration has been so focused on the undocumented population that as of yet, there has not been a lot of impact in the employment-based space. We are currently in the midst of the H-1B cap lottery, so that will start the first week in March, and it will go until, I don't remember the exact date, but the end of March. And so, we're proceeding as per usual. Our firm's deadline to accept cases is February 28th, but everything for the H-1B lottery right now is as it was last year. And there has not been any other specific impact on employment-based cases. Obviously, what Dree just talked about, the decreases in the federal workforce, will impact the speed of processing of cases. We do expect that all employment-based green card cases will be interviewed, so there will be some changes, but I would expect that in, over the next year or the next 4 years, that there will be many changes to employment-based immigration. But as of now, not a lot is happening. Even with regard to audits and raids, that's a big topic, and we do expect action, a lot of action on that in the near future. But to be quite frank, there hasn't been as much action yet as we might have anticipated. So there's a lot of talk and not so much action. There is one provision that I wanted to raise, which has impacted employment-based immigrants, but it was hidden in Project 2025, and I thought it was really important, and it's about potential sanctions against recalcitrant countries. So those are countries that refuse to take their foreign nationals back, and we've seen this theme over and over in terms of populations or individuals that the administration wants to remove, and they can't remove because their home country won't take them back. Project 2025 specifically mentioned countries including Russia, China, Cuba, and Iran, but there are other recalcitrant countries. And, basically the Protecting the American People Against Invasion executive order directed the Secretaries of State and Homeland Security to impose sanctions against such countries. Mandates diplomatic efforts, and non-cooperation could trigger additional sanctions. The one case that really surprised me, so you might remember there was a 24-hour trade war with Colombia where we imposed increased tariffs on Colombia, and there were some World Bank staff that were deported that Sunday. I don't know the details, but it was publicly reported that during this 24-hour period, because Colombia refused to take its foreign nationals back, the administration snatched up a bunch of World Bank employees and removed them from the United States. So I think that's when we talk about employment-based immigration, like there are no general policies that changes at the moment that are impacting all employment-based immigrants, but if you are from a country that gets into a trade war or a fight with the administration, it's possible that, that other actions like that could occur. So I think this idea about recalcitrant countries is very important to the current administration, and we should be aware of it. We have just a few minutes left. There were two questions that maybe we could try to address. The first was about unaccompanied minors, whether we have seen any changes or we have any updates with regard to how unaccompanied minors are being treated, especially with regard to detention and deportation. Does any of you want to address that?
I just answered that one in the Q&A.
Thank you.
So I can share what I shared on there. So there haven't been a ton of changes yet, other than in immigration court, the Executive Office for Immigration Review reverted back to its policy memorandum from 2017. It's an 8-page memo, and it lays out how juveniles are to be treated in immigration court. It touches on unaccompanied minors in it. So I would recommend people take a look at that if you're interested in those issues. It's OPPM, I think 17-03. I think I said in the chat. Let me see if I can find it. But I think the most concerning thing for unaccompanied minors there is the policy that immigration judges should basically reevaluate an unaccompanied minor's status as a UAC at the point of adjudicating the benefit. So previously the policy was, once you're designated as an unaccompanied minor under the law, you're always going to be designated as such, even if you age up, even if you become an adult, even if you reunite with a parent, something like that. But the new policy, and this was challenged previously as well, is that that's not static. That kind of unaccompanied minor designation can shift over time with things, you know, age changing, parentage changing. And so what that means is even if someone was designated as an unaccompanied minor before, that in immigration court, a judge can reevaluate whether they still meet that legal definition under the statute. So, you know, I don't know if that will continue to be challenged. There's the JOP settlement. That was the previous litigation on these issues, which resulted in a settlement. And so I don't know if this will continue to be challenged by organizations representing unaccompanied minors, but that's kind of the main change that I noted at this time for children.
Wonderful. Thank you so much. All right.
Becky, if I may, I'm sorry, I was just going to add one little detail, which is that there's a settlement called the Flores settlement, which basically is an agreement that the government signed in the 90s after a lot of litigation that started in the 80s that calls for certain humane treatment of unaccompanied children in detention. And that compliance with that settlement is under a court-ordered monitor, and the judge who is overseeing that compliance extended that settlement agreement and the monitoring under it for another 18 months. So that's going to last through, and that was like earlier this year in January, I think. So it's going to last through the middle of 2026.
Okay, thank you. So I want to touch real quickly on 2 questions about processing time. Someone said, I submitted my application for citizenship while my removal of conditions is still pending. Would this also be delayed? Another person said, owing to the anticipated increased processing times, I wonder if premium processing will be suspended for H-1B petitions. I think overall, we can say we expect that every type of application, every type of petition is going to take longer because of the staffing that they're taking away. Premium processing is funded by fees. So we have not heard anything specific about premium processing being suspended. They might increase, they definitely talked about a fee increase. I would be more inclined to think that they would increase the premium processing fees rather than suspending it. But I think one thing that we know is that anything is possible. And we're actually 1 minute over time. So I guess we should probably wrap up with that. It was really great to have everybody join today. This is a series of webinars, so we'll be doing this again in another month or so. And we hope that you'll be able to join us again next time. Thanks so much, everybody.